It looks like the Supreme Court will take up an elections case that could have major consequences across the country. So we want to bring in legal contributor Jessica Levinson to explain this case and what is at stake. Jessica, as I understand it, the case is about whether state courts or state lawmakers should have control over elections. And we're talking about things like redistricting, which could make a huge difference in the outcome of an election. What's going on, and what do the petitioners want?
So you're exactly right. This is a question basically of whether or not state lawmakers will have unfettered discretion, meaning unchecked, meaning state courts can't review what they're doing when it comes to federal elections. And that's because what we're really looking at here is two provisions of the U.S. Constitution that say state legislatures, that's the words that they use, state legislatures, one, determine the time, place, and manner of federal elections, and two, determine how to appoint electors for the Electoral College. Now, obviously, if that word legislature just means state lawmakers, which is not our current understanding, but is what proponents of this theory are pushing, that would mean, exactly as you said, that state lawmakers could change laws regarding, for instance, how we pick electors for the Electoral College, gerrymandering, suppressive voting laws. We just heard from Caitlin about some suppressive voting laws, in my words, in Georgia. And that would be a huge change for federal elections. And that's the theory that proponents are pushing here, which is that legislature doesn't mean what we think it means now. Everybody involved in lawmaking, meaning election administration officials, secretaries of state courts, it just means lawmakers.
And considering the wide-ranging and far-reaching implications of this case, what do you make of the fact that the justices agreed in hearing it? And when in history have we seen these arguments invoked and made, and how did those cases play out?
So if they do decide to hear it, it's 4 votes to hear it. And we know that I would say, conservative wing of the conservative wing, Clarence Thomas, Justice Alito, Justice Kavanaugh, Justice Gorsuch, they've said in other cases, particularly in post-2020 election litigation, that they want to hear more about this, basically. We also have Justice Barrett, not one of that 4, have a comment recently and say some version of, we're going to have to tackle this sooner rather than later. I would say not unless you want to give it some credence. This is one of those theories. It first kind of appeared in its infancy and maybe an embryonic stage when Chief Justice Rehnquist at the time wrote about that famous Bush v. Gore decision. It was part of his separate opinion. It was just dicta, it wasn't controlling. People basically ignored it, but it's gained a lot of steam. And we saw that theory come up with much more prevalence in the aftermath of the 2020 election. Again, I think for people to remember, this is important. If the court, or at least 4 members of the court, had no interest in exploring this theory, you don't potentially take the case. It's just like a number of other decisions, just like the abortion case. If you don't want to change the law, you don't take it. Same thing for the affirmative action case for next term. If you don't want to change the law, you don't take the case.
And I just want people to sort of understand what's happening now that would, why we're having this conversation. And you mentioned gerrymandering. I think it's sort of the best way for people to kind of understand that, when a state legislature is sort of redrawing that map, if it appears biased in some way, then the courts can intervene and say, go do it again.
So, and that's exactly where this theory, you're exactly right to push on that particular issue. That's where this theory is coming up a lot right now, which is, for instance, in certain states like Pennsylvania, like North Carolina, state lawmakers drew these district lines. And the argument was that they violated the state constitution. And the state, in some cases, the courts actually redrew the lines. This would take the courts out of that process. This would say that when it comes to drawing those district lines, for federal elections, that it could only be federal courts that would be able to jump in and say, we think under federal law, there's a problem here. But we know from cases just a few years ago, the Supreme Court has said, when it comes at least to partisan gerrymandering, we don't belong here. So that would give so much power to state lawmakers to draw those ever important district lines. It could also upend systems like I'm in California. We actually have an independent redistricting commission draw those lines. We take our state lawmakers out of it. Those would be called into question too if the court gives its blessing to this independent state legislature doctrine.
Wow, seismic impact. If this case is considered, we'll keep watching. Jessica Levinson, thank you very much.
Thank you.